everyone. Welcome. I'd like to thank you for joining us. My name is Melissa Doman, and I'm the Senior Policy Counsel with the National Juvenile Justice Network. And I'd like to welcome you on behalf of the National Juvenile Justice Network to our registration reform webinar. So the webinar is being sponsored, as I said, by the National Juvenile Justice Network, and we are a membership organization made up of state-based groups, all working to ensure that the juvenile justice system is fair and age-appropriate for youth in trouble with the law. So we have a wonderful group of presenters today that all have a great deal of expertise in the area, and you should have received their full bios when you registered, so I'm just going to briefly introduce everybody. Lisa Swaminathan is a staff attorney at the Juvenile Law Center, where she works to enforce and advance the rights of children and youth in the child welfare and juvenile justice systems. And Lisa has developed litigation strategies to challenge registration requirements applied to youth who have committed sex offenses. Then from the Center on Youth Registration Reform at Impact Justice, we have Nicole Pittman. Nicole is both the founder and director of the center and is also a Stoneleigh and Rosenberg Leading Edge Fellow. And Nicole has worked exclusively on questioning the wisdom of placing children on sex offender registries since 2005. Hannah Miller is a program associate with the Center on Youth Registration Reform, and her work encompasses policy research, legislative analysis, and communication strategy, and she has previously served as a court advocate for survivors of sexual harm. So with that introduction, I'm going to have our presentation get started, and our first presenter is going to be Lisa Swaminathan, so I'm sending the screen over to her.
Good morning, or good afternoon. I'm just gonna, can everyone see me?
Yes, looks good.
All right, great, thanks. So I'm gonna be giving everybody a brief overview today about what SORNA is. I know that many of you on the call today are very familiar with SORNA and its requirements, but I just want to be sure that we're all on the same page before I hand it over to our policy experts, Nicole and Hannah. So what is SORNA? At bottom, SORNA is a federal scheme that labels individuals who have committed certain offenses as sex offenders. And it works by withholding money from states who don't enact their own rules implementing the federal requirements. And this is a generalization. Some states have their own sex offender registration schemes that are completely independent of or very independent of the federal system. And so these laws look different across states. But in general, when we talk about SORNA and sex offender registration, we talk about systems that are labeling individuals as sex offenders. And that label can apply based on the offense that the individual has committed. It can also apply in some states for any offense that is sexually motivated. And this means that individuals can be labeled sex offenders for conduct that ranges from anywhere from very low-level sexual assaults to statutory rape to Romeo and Juliet type relationships. In some jurisdictions, kidnapping, regardless of sexual motivation, can lead to being labeled a sex offender. And also very serious offenses. So more severe sexual assaults and rape can also mean that somebody is labeled a sex offender. SORNA generally follows a tier-based system. Most jurisdictions have 3 tiers, where with the lowest level offenses being labeled tier 1 and the worst offenses being labeled tier 3. And in most instances, SORNA's restrictions and how long its requirements last depend on which tier an individual is categorized as. In states that follow the federal scheme, SORNA's requirements will last anywhere from 15 years to life, depending on the tier that an individual is assigned to. And what's most important for today's purposes is that in most states, SORNA applies to delinquency adjudication. So if you think about in your jurisdiction, the minimum age for a delinquency adjudication, the fact that registration can continue for life, we're talking about really severe consequences for youth. And in many jurisdictions, the rules are the exact same for young people as they are for adults. The first step of SORNA starts with registration, and SORNA requires that individuals submit certain information to state officials immediately upon entering the community. So upon being released from a secure facility, upon starting probation, right after adjudication, they have to show up in person in many cases, and sometimes not, and provide what is sometimes very extensive, technical, or invasive information. Some common information that individuals have to register, things like their name, their address, where they work, and then it varies largely from there. Most states require a photograph. Sometimes individuals have to provide DNA samples, photographs, things like their internet handles, so names that they use on social media sites might be registered. And in some instances, the registration requirements apply differently to different categories of people. So for instance, individuals who are experiencing homelessness can't register a home address. So some jurisdictions require that they report places where they frequent. So really the type of information can be very extensive. What's also important to keep in mind about registration is that many individuals have to register in multiple jurisdictions, and that's because SORNA requires individuals to register where they live, where they work, and where they attend school. And different jurisdictions define those terms differently, and in some instances broadly. So what I might consider a vacation to Florida, Florida defines as residing in the state. So going to the beach for 5 days, individuals are required to register in Florida. Work in some cases can mean volunteering or even visiting an office out of the state that where you regularly work. Attending schools, in some instances going to a library at another university, could be defined as attending school and trigger registration requirements. The second step of SORNA's reach is notification. And many jurisdictions require community notification. And even when registration information is private, which it is in some jurisdictions, it may still mean that an individual's status as a sex offender and all of their registered information becomes public nonetheless. There are a lot of reasons for that. One of the main reasons is that in many jurisdictions, registrants' information is published to websites, is published to publicly accessible websites. There's a national website that draws from each state website. And as we all know, living in the age of the internet, once information is out there, it's out there. So even after registration requirements end at 15 years, an individual's status as having committed a sex offense is out there, and it can be really hard to erase. Notification is not just limited to publication on websites. Some jurisdictions require more affirmative community notification that can look anything like written notice to neighbors, to schools, to community organizations, and in some instances, the status is printed on people's driver's licenses or other state identification. So, so the idea that a person has committed a sex offense, even a young person, and that information remaining private, it's just not the reality of what's happening. And this is true for young people. At least 28 states include juvenile offenders on public registries with little or no restrictions. So in each of those jurisdictions, anyone who's required to register, that information is going to be public. Reporting is another requirement of SORNA schemes. And that when we talk about reporting, we mean the requirement that individuals update their registry information at regular intervals or when the information changes. In many jurisdictions, reporting has to be in person. So an individual is required to register, has to physically go to the police station to update or verify their information. And for young people, this can be very challenging because offices are open at limited hours. Young people have to go at a certain interval or whenever their information changes, so that can be pretty demanding. So if they are visiting a school out of state, if they have a new social media platform that they're using and a new name, they might be required to report to give that updated information. But what we know about young people is they are not always in control of their own schedules or their own ability to travel. So physically getting to places to update their information, or just the idea of being a young person who may forget or is rebelling, means that they may be unable or unwilling to comply with reporting requirements. SORNA also carries a lot of different restrictions on things like travel, residency, education, work, and family relationships. Some of these restrictions are explicitly written into the law, and some of them are unintended consequences of the registration, notification, and reporting requirements. Just as an example, when we talk about travel, there are 23 jurisdictions that require registrants to wear GPS monitors, and that may include a restriction on where they can go and exclusion from certain geographical zones like schools, parks, other places where young people might be. And there are also unintended consequences of registration that impede travel. So the idea that people have to register in states if they've spent a certain period of time there may impede travel between the states. Restrictions on residency. One explicit restriction is that people who are labeled sex offenders are ineligible for public housing. In terms of education, status as a sex offender is sometimes reported to schools. Some statutes even restrict stepping onto school grounds for people who have committed sex offenses. And in some instances, this includes young people who are still of compulsory school attendance age. In Alabama, for instance, a young person who has committed a sex offense and is labeled as a medium or high risk of reoffending may be excluded from public schools. The same is true of work, that some professions categorically exclude people who have committed sex offenses from working in the field. And one of the areas where we see a lot of unintended consequences is in the area of family. We know that in some states, people who have committed sex offenses are barred from living with minors. So for young people who are registered as sex offenders, that might mean if they have a sibling, their family has to live in 2 separate homes because they're not allowed to live with their own sibling. What we also know is that because SORNA's requirements can last a lifetime, people who have committed sex offenses in childhood who then grow up and start their own families may face some barriers when it comes to living with their own kids. Also written into law are some pretty serious consequences for failure to comply. When we talk about failure to comply, we mean failure to register or improper registration or reporting. So not showing up on time or providing false information. Failure to comply in many instances requires prosecution. There's no discretion in terms of what a young person can be charged with or even what the consequences are. In many instances, failure to comply is a felony, and there's frequently no defense. If you didn't register or report properly, you've committed a felony, and the consequences can be severe. So for instance, in South Carolina, failure to register or knowingly providing false information for the first offense can be a misdemeanor, but it still carries a fine of up to $1,000 and detention for up to 365 days. For subsequent offenses, young people can be charged with a felony that carries a mandatory 5-year sentence. And so again, the consequences are severe, especially because we know young people have such a hard time complying. What is also really important to keep in mind is that we know registering young people does not improve public safety. And this is a really important point because that is the point of sex offender registration. There's an idea that if the community knows who sex offenders are, they can prevent themselves from being victimized. The problem with this reasoning as applied to young people is, well, it's severalfold. The first is that children who commit sex offenses are highly unlikely to commit a subsequent sex offense. That's because kids are developmentally different from adults, as the U.S. Supreme Court has recognized. They are less culpable for their actions, more amenable to rehabilitation. They're less mature. They're more vulnerable to negative influences. And so what we know about young people who commit sex offenses is that they're likely to reform. They're not likely to continue to offend in adulthood. What we also know is that sex offending among children is similar to other forms of delinquency. Young people do not commit sex offenses out of a sexual motivation, but generally their act arises out of impulsivity, sexual curiosity, and just delinquency more generally. What we also know is that sexual recidivism among youth cannot reliably be predicted by any factor. So it's not just that a person who has committed a sex offense in childhood is unlikely to commit a sex offense in the future. We can't look at the circumstances surrounding that offense or any other characteristics of the youth to be able to tell whether they are likely to offend again. And that's because the sexual recidivism rates are so low that it's very difficult to extract to figure out who's likely to commit an offense in the future. We also know that registration itself does not reduce recidivism. So just the act of registering is not preventing future sex offenses. And again, that is in part because the rates of recidivism are already so low among juvenile offenders. On the flip side, subjecting youth to registration carries very severe consequences. Young people who are subject to SORNA are, among other things, reminded sometimes every 3 months that they're a sex offender. And we know that these labeling effects carry very real harms to kids. On one hand, it alters their self-image. Young people tend to live up to this expectation of themselves that they're a sex offender, that they are bad people, and that they will continue to do bad when that is what society expects of them. From a societal viewpoint, I think when we all hear the label sex offender, we have very strong feelings about that. And it's impossible to divorce a young person who is labeled that way from who they are as a person, even when their offense occurred a long time ago. So carrying that label around not only changes their own views of themselves, but it changes societal views of who they are as well. We also know that registration makes the young people who are subject to registration less safe. So registration, we know, is associated with an increased risk of suicidal ideation and suicide attempts. We also know that young people who are required to register are at an increased risk of sexual victimization. And that's compared to other young people who have committed sex offenses who are not required to register. So it is the actual act of registration that is associated with this increased risk of sexual victimization. So by registering young people, we're subjecting them to the precise harms that registration schemes are supposed to protect against. These are just some themes to keep in mind. I'm going to hand it over to Nicole, who is going to talk a little bit more about these themes and about how you can use them in your advocacy.
Thank you, Lisa. That was fantastic. Fantastic. And so my name is Nicole Pittman, and show my screen. Sorry, I want to wait a minute. Sorry, give me 1 second. I didn't pull up the PowerPoint. While I am pulling up the screen, let me just talk a little bit about, just very quickly, I'm going to get into the federal landscape and the state landscape, and then talk about sort of steps that you can do on the ground for yourself. So why Hannah is helping me, I'm going to just start and talk about very quickly some things that Lisa, to emphasize that Lisa touched on. And those things that Lisa touched on are really important. And one thing I want, and these are all about references, if you are going and talking and legislation comes into your state, either whether you're working on it proactively or defensively, to remember that this is the only instance in juvenile court where children are, for lack of a better term, treated like adults, and they have lifetime consequences. And where we can't bring cameras into court, we can't use the name, we have to use initials of the children. All of those things are happening All of those things are for the protection of children deemed to be in need of rehabilitation and in juvenile court, except when it comes to sex offense, when they've committed a sex offense. And what that is turning into is that our kids are being treated just like adults and remaining in the juvenile justice system. And so we're going to talk a little bit about the harms that you can put into when you're discussing with lawmakers to beat back the laws, or somebody is thinking in a state to think about implementing the laws. But one thing that I want to emphasize is that Lisa touched on the brain science, and just something that's just always in the back of my mind is in 2005, Roper v. Simmons got rid of the death penalty for kids that commit offenses under the age of 18 using brain science. At the same time, so that's kids that have committed murder and really top of the top heinous crimes. We said we can't judge them on what they've done, and we cannot execute them. And at the same time, we increased and passed the federal Adam Walsh Act, which requires children to go on the registry for life. And so with all that brain science, all of the information, we went in the opposite direction that we were going for children. And it's really important to start working and getting ahead of that. The second thing I want to say is my work is going to be changing. And I'll just very quickly say, the best way to summarize my work over 15 years of working solely on ending the practice of placing children on registries is a dog chasing a frisbee, and me being the dog. And going state to state in around 2005, 2006, to 2009 to 38 states to try to convince people to not put children on registries was the first part, the first frisbee. The second was at those hearings, hearing lawmakers say, I don't think this is a good idea, but I don't have any choice. I don't want to lose my job. I don't want to lose the next election. So if you could bring me information on what's the harm of placing children on the registries. 2011, I go on the road and do 500 interviews of kids that were raised on registries, and most of them are 30 and have been on the registry since the age of 8, 10, 12. Bring that information back, and I'll talk a little bit about that harm. And that's still not enough. And then next, we hear on the federal level in many places, if you could bring us these groups, law enforcement, survivors, and Republicans, and they can agree that kids should not be in the Adam Walsh Act, we'll make some moves. That didn't happen either. And so really, now the question is, people say, in order to get rid of registration for kids, we need an alternative. And at first I thought, well, perhaps we could have an alternative program instead of registration. But now my work is really about, we're not doing anything for prevention, and it's now time to just blow that all out of the water and really start to work on more effective practices of ending child sexual abuse, and in this case, child-on-child sexual abuse. So a lot of my work is going to be changing, and that's why it's really important that we have you all in the states doing this work. And you see why RR will then become more of a resource center. So getting into the presentation, on the federal landscape, I think we have one of the main people that's working with me on this, Liliana Coronado, on the line. She's with the Brimley Group, and we met years ago when she was working for Congress. She's now working going every month, going and doing visits on the Hill, and she's gone with Republicans from Right on Crime, from R Street. She's gone with conservative survivors as well as progressive survivor groups. One is Stop Child Predators, and different members of survivors, including Patty Wetterling, the first person, is something that we're working on. The first person to start registration, federal registration, is a partner of ours that we're working with that says this was not intended for children and children shouldn't be on the registries. We're also working with law enforcement, and I'll talk a little bit about that. And so the federal landscape right now, as you know, is difficult. It's not impossible, it's difficult. Conservatives are very, very supportive of getting changes, and I'll talk a little bit about that. And on the state landscape, I think the state landscape is going okay. It's made me realize how hard it is to make changes and how time intensive it is, but it is, especially when you're flying into a state. We've had some great movement, and we have some great movement ready. The latest is California, which has been registering children, juveniles, since 1986 for life. And one of the changes we made there that Hannah's going to talk a little bit about later is we've gotten rid of lifetime registration, and now children can petition to be removed after 5 and 10 years, or 10 years, depending on the severity of their offense. That hasn't gone into effect yet, and we are working on, which I can talk to you about a little bit later, we are working on looking at why some of this existed in California that might be interesting to some of you, is that there's California State Sex Offender Management Board, which is the board appointed by the governor to look in and weigh in on conditions or what's going on with registry, had no authority to talk about children. So when they passed this bill to say we have too many adults on our registry and we want to put them in tiers, no one put children in there. So so Hannah's going to talk a little bit about that later, but even just making sure that there's a state sex offender management board that actually has authority to look in, research, and weigh in on children is very important. And so as I move on, I just want to say there's 3 ways basically to end registration for youth. Litigation, which I believe is going to be very key, and that's what Lisa and Juvenile Law Center are doing. It's been declared unconstitutional in Pennsylvania to put a child on the registry, a child from juvenile court. They've had some movement in Ohio. We've had some movement in New Jersey where lifetime registration has been struck down. And I truly believe getting a case up to the Supreme Court is one way of just absolutely abolishing these laws. The other way is working on the Federal Adam Walsh Act, which we're doing, and getting children removed from the Federal Adam Walsh Act. It took about 2 sentences to add kids to the whole several hundred-page bill, and all we ask is that they take those 2 sentences out because it's actually not making sense. And there's a lot of due process issues and so on and so forth. And then on the state level, where I think there's a lot of robust, there's hope actually on the state level, and that's what I'm going to sort of focus on here for you all. So first we go into some of the impacts of youth registration that came from my 2013 report raised on the registry and have continued to proliferate. We've seen this on so many levels, and that's barriers to education that Lisa mentioned. And for kids, when we're talking about a 10-year-old, it's not being able to go to elementary school. And so when people go and pass laws and say registered sex offenders are not allowed on school grounds, sometimes it takes just going to have a conversation with the author of that bill to let them know that children are also on the registry. Some of them want children to be removed from school, but most don't, and they don't realize that it's affecting children as well. So that sometimes can be something that's you can beat back. Of course, being on the registry for kids can be a housing instability issue that goes on until adulthood. Barriers to employment, which are increasing as the laws say that you have to put your employer on the registry with you, on your registration information. Economic issues, of course, not having a job and also paying fees and fines. Family harm. Something I want to say is that, when we're talking about children, and that's one of the entrance points of what I'm going to be doing on prevention, is the registry is the most harmful thing to deal with intrafamilial sexual abuse, because usually it's many times between a brother and a sister, or a cousin or someone living under a roof. And so the point of putting somebody on a registry for the whole world to see in many cases is also doing damage to the survivor. One young woman that I worked with and interviewed when she was hurt by her brother when she was 12 and he was 14, she said, I want everyone to know that I was on the registry myself as a victim because my address was seen. People knew that I was the victim. And she said, people should know that a child on the registry is a family on the registry and also a victim on the registry. And we try to let people know that, a lot of lawmakers. Psychological harm, which I will get to in the next few slides. Exposure to violence. We think about, in most of California is an example where they don't put the date of when the incident happened on the registry. And so when you have a 14-year-old that is arrested and put on the registry for a crime, against a child under the age of 14, let's say a 13-year-old. When that person is 33, all you see is indecent liberties with a child under the age of 14, and you immediately think a 33-year-old did this to a child, not realizing that they were both children, and not taking away from the harm that was done. But vigilantes look for this, and we've had many of our registrants killed, harmed, set on fire. Cycles of incarceration. Most of our kids are getting 3 and 4 failure to register violations, which are, as Lisa said, they are felony convictions on their record. So we've been able to get kids off the registry, but they still have felony convictions for failure to register, which can be as simple as your shoe size growing, and you're not going to update that within 3 days. That's considered a failure to register. That can be servable in prison and with a fine for a child. So something that I really want, this is very important for the work that you all are going to be doing, is that sort of anecdotally we've been able to research the most common paths to kids being on the registry. And the most common paths are system involvement. And when I say that, I don't mean in the juvenile justice system. From my research and interviewing 500 people, we finally stepped back and said, let's look at these questions. We asked the question, were you in the child welfare system before the juvenile justice system? And so that means, were you in the child welfare system? Were you a victim of something, not so much sexual abuse, at the time or before you committed the sex offense? It came out to be 100% of the kids we interviewed from Raised on the Registry were established victims in the child welfare system. And so it makes you say, what is going on? Is there unmet needs, trauma? And it's not always somebody that's sexually abused goes on to sexually abuse. There's some unmet trauma. The second thing about that system involvement that we're seeing a whole lot of is children that are in the foster care system that are living in foster homes with other children that aren't their siblings are being raised by a mandatory reporter. So things that are normal behavior in a home, your own home, could get you arrested. A child that keeps not taking their towel to the bathroom and runs around naked when he's 14, and he has 5- and 6-year-old foster brothers and sisters, and the foster mother reports that could become a registrable offense. So we're seeing kids that are highly surveilled also being criminalized and put on the registry. The second is a parent seeking help. We have one program in the U.S. that just started a pilot that takes 13 kids called Help Wanted that is getting around mandatory reporting laws, and a parent can take their child there if they think they're acting out sexually. But other than that, there is no place that a parent can take their child and say, my child has been doing some inappropriate things without that child being arrested. And so when we think about prevention and we think about healing and we think about just getting ahead of and not criminalizing kids, we don't have a system for that. And so one of the second highest rates of children going on the registry is a parent trying to seek help, going to a pastor, a therapist, a teacher for help with their child. The third is a very interesting one that we've learned by doing some partnerships with rape crisis centers, is we're seeing several kids that are on the waiting list at a rape crisis center for being victimized, and while they're on the waiting list, acting out sexually. Not everybody that is harmed acts out sexually, but we're seeing a bridge where some of those kids that are not being seen and treated are acting out, and then they're arrested, and they're no longer seen as victims. They go through, there's a pipeline, and they go on the registry. So those are important points, especially when you're talking about who the registry laws are going to apply to. They're applying to, many times, victims of neglect and abuse. And so that takes us on to Dr. Letourneau's research, with Lisa mentioned, and this is brand new research, just came out at the end of 2017, and compared to non-registered youth, registered children are 4 times more likely to have attempted suicide in the past 30 days. So going to a lawmaker when he's trying to pass a bill or she's trying to pass a bill and saying, number one, we have vulnerable children that are being placed on registries. Possibly 100% of the children that go on registries were in the child welfare system. Putting them on the registry can make them 4 times more likely to attempt suicide and 5 times more likely to be sexually victimized by adults. And what that means is that children are then, on the registry, are then put in positions where they are available to adults that might be interested in kids sexually. By being on the website, you can find their address, where they go to school, all of those things, and also where they have to go register. They don't separate adults from children. Children have to go to the exact same place and sit and wait for 8 hours. The rate of recidivism among youth who commit sexual harm is 2.75%. It just can't get any lower. It's just scientifically not possible because the numbers are already so low. However, we can't get much lower than 2%. However, we're starting some new research, and we're seeing in states that do not register children, your New Mexicos, your New York, your New Hampshires, the recidivism rates are actually lower. They're closer to about 1.5%. And so what that tells us is the registry doesn't have any bearing on recidivism rates for kids. It's not stopping. It's not actually helping public safety. And that's an important thing to say, especially in the states where people they don't register kids and they're trying to think about putting kids on the registry. And it's an important thing to say when you're starting to give examples to lawmakers where they're ratcheting up the states for children on sex offender registry. So the annual cost of youth registration practices, and this was a study done by my colleagues on the conservative side, R Street Institute, is $3 billion for an ineffective practice that has never been shown to be effective for public safety, reducing incidents of sexual harm, just for children, $3 billion. And in a couple slides, I'm not going to go too much longer, in a couple slides, I'm going to talk about how you can use some of these numbers in your state. Actually, in just one or two slides, only a few more minutes left, and then I'll turn it over to Hannah. So what we've been doing is this research that we have, or not just research, is building partnerships and building messaging around that. So we work with Republicans, so you can go into a state like South Dakota where almost everyone is a Republican, and have somebody that's with you, and so that bipartisanship support, whether that's Right on Crime or R Street, and we can offer that to you, and that's available so that you can have both sides of the aisle. Law enforcement, we started working with Detective Schilling, he's a consultant who is starting to build up our law enforcement database, and people that are interested, that are in law enforcement, that are interested in fighting the registry. And we're talking decorated sex crime, special victims crime detectives and their police officers who did a survey saying, do they think kids should go on the registry? So far, it's coming out somewhere around 8 out of 10 are saying that they don't believe kids should go on the registry. And so we're really working on getting that law enforcement support. And in some states, it's already happening, like West Virginia. Survivor communities, in every state, we are working with the Alliances to End Sexual Violence and the Rape Crisis Centers, and we want to be able to match you all up with the survivor organizations, because the main thing that lawmakers say is, we're doing this on behalf of the victim community and the survivor community. And then they really can't say that if somebody who is head of the survivor community is standing there. And a lot of the reasons that we've gotten that is that 100% of kids being in the child welfare system. Survivors want to take back their survivors and start to help them. So before I turn it on to Hannah, I just want to give you a really quick example of what we did in California. And this is with just Hannah and I. That's our staff, and just kind of getting some public data and research that helped drive the conversation and move us towards eliminating lifetime registration. So in California, we realized because it's based on a judge deciding if a child is going to go to this one facility, and that one facility is what kicks off lifetime registration. So what that means is if you have a sex offense in California and you don't go to this one facility, you're treated in the community, you don't go on the registry for life. If you go to this one facility that has about 200 beds, you go on the registry for life, even though you're getting the best treatment in the state. And what we're also finding is the people that are being sent there are black males. And it's also, the other thing we're finding out, it is not for the underlying sex offense. It's when you have a sex offense, you're in treatment, and you go and steal a car. You get put in this facility and put on the registry. And so it has nothing to do with public safety. And Black youth are 6.5 times more likely than any other race to be placed on the registry in California. The closest disparity we were able to find is Alabama, which is that Black youth are 2.5 times more likely. That was a startling statistic for lawmakers and law enforcement that made them pay attention. The other thing is cost. It's cost $140 million in California just to run the juvenile registration system. It's basically defunct. No one likes it. No one wants to use it. They hate it. And it's $140 million. And at that same time, when we were considering the bill, we found out that Governor Brown was only able to pass a bill with a budget for victim services for $46,000, which comes out to about $1.54 per survivor. And so we wanted to go, we kept talking about flipping those numbers. And that was another huge determinative factor in that move here, is where our resources are going. And so we can talk to you a little bit more, but I'm going to turn it over to Hannah. We can talk more about how to do that, and I'm available. Let me turn this to Hannah. Sorry. Change presenter, and Hannah. Take it away, Hannah.
I'm Hannah. Thanks, everyone, for joining us today. I'm going to try to fly through this. So part of my job at CYRR, well, most of my job at CYRR, although there are a lot of different things that I do, is taking on legislative and media tracking. And so I'm just going to go through my work from the past year and talk about some trends and lessons that CYRR has learned over the course of 2018. So the two main trends that I've seen over the course of my work the past year is that youth are getting swept up in bills intended for adults on the registry, as well as being intentionally targeted through very specific legislation. And both of these trends have led us to different strategies and different approaches in our work. So first off, we have just these series of bills where kids are just being swept away in a system that was intended for adults, which is historically what the registry was intended for. It was never written to apply to children. And so a big reason for kids getting swept up in these increasingly restrictive bills is that a lot of lawmakers literally don't realize that kids can be included on the registry. Or they just may not believe that there is a distinct difference between kids and adults who've caused sexual harm, which we know is not accurate. We had two bills in California where this happened. The first was the registry tiering bill that Nicole talked about. In its original form, it moved adults to a tiered system, but had no mention of juveniles. And so had it been implemented, adults would have been tiered, but kids would have remained lifetime, which is pretty outrageous. So while that was pretty frustrating, it actually created a really great opportunity for us at CYRR to engage in this issue, talk to our lawmakers, build great coalitions across the state, and we were actually able to get youth placed on even shorter tiers, which is terrific. We would have loved to get rid of it altogether, but that's next. So that's this one category of bill, just kids are unintentionally being caught up in a system that's intended for adults. And the next thing we see is these laws that are clearly specifically targeted for youth. And so there's kind of two forms of this type of bill. One would be a bill that is trying to expand registration and make an increasing number of restrictions or punishments for kids who have been adjudicated in juvenile court of causing sexual harm. So we have seen in this past year, there was a bill in Connecticut to introduce registration for kids for the first time. Connecticut is a state that has historically not registered kids, and the past 2 years, actually, we've seen these bills pop up trying to start registering kids, and we dug into it, and what we found is that it was actually tied to one specific case in a particular community where there was a relatively high-profile event, and that triggered community, I guess, involvement and asking for registration. We saw in Alabama an expansion of registration. In Kansas, there was a proposed bill to expand registration as well. So happy to report that Connecticut and Kansas both did not pass, but Alabama unfortunately did, which is an ongoing issue. But basically what we found in every single one of these cases was that the legislation was tied to a specific incident. It was tied to one specific case in the community that just propelled it into the State House, basically. And so it's, again, this phenomenon of creating legislation based on really individualized cases, which we know is an ineffective response. Furthermore, overwhelmingly, the laws proposed would have actually had no impact on those specific cases in question. For example, the one in Connecticut, had the law passed that was proposed, it actually wouldn't have had an impact on the case that triggered the law itself. But again, this phenomenon makes perfect sense in the context of the history of registration. We respond to sexual harm in a way that's very reactionary and very individualized, and it's well-intentioned, but it's not effective. We actually, in Kansas, I was blown away because there was this very restrictive bill that was coming up, and lawmakers actually said, hey, this is an awful case, but we can't legislate based on a case-by-case basis. We can't use this incident to build the whole system, which was pretty impressive. So we were excited to see that. The other type of targeted legislation that we also see that I think is also an opportunity for engagement is there are a lot of bills popping up here and there addressing specifically sexting and trying to create exceptions for kids who are engaging in sexting or other teen dating issues. And, you know, at CYR, we're not wild about this type of really specific legislation because it only applies to a few youth who are deemed to be good or not dangerous. And as Nicole and Lisa have both pointed out, registration isn't effective regardless of the offense. It doesn't matter what the crime in question was. Registration does not work, and it is universally harmful. So while we're not wild about a bill that only provides relief to kids who have been caught up in the system for something like sexting or other normative teen or child behaviors, I do think that this conversation and this issue does present a pretty great opportunity to engage with people and engage with the public on reframing how we conceive and define normative childhood sexual behavior, because that's a huge way that we know kids are caught up in the registry. And it's not just sexting, it's a huge range of other behaviors. And so it's inadequate just to provide relief for a very, very specific normative behavior when there's a whole range that continue to be criminalized. But I mean, even these efforts can pave the way towards further reform, which we are excited about. So what can we do to be involved in this issue? I think number one, become familiar with the laws and the language in your state. So just try to establish like a baseline of what the registry looks like in your state for kids. And also keep an eye on the language. So, you know, in most states, the language uses sex offender registry. In some states, it's a sexual offender registry, and in others, it's a predatory sexual offender registry. So know what those search terms are so you can be better informed. I'd also really recommend creating saved searches on legislative tracking websites regarding registration and juvenile justice. A lot of states have, states have really great tracking systems that you can actually use, and you can set up alerts for yourself either on your state's website, or you can use a system like BillTrack50, which I use and love. Thank you, BillTrack50, or Legiscan. And I believe if you're only looking at one state, both of those are fairly simple and accessible. I also recommend just keeping an ear to the ground on high-profile news or incidents that could possibly trigger legislative backlash that could be used to harm kids. For example, the cases we saw in Alabama and Kansas were absolutely both fueled by that. And so seeing that this past year, what I've started doing in my own work is creating these news alerts as well, and keeping tabs on states where there are high-profile issues of child-on-child sexual harm, so we can kind of take the temperature of that state and be ready to engage with the bill if it comes out, or engage ahead of time and get out ahead of it. So those are the three things that have made my job a lot easier, and I think have made me more effective. And I'd encourage anyone who's at all interested in this issue or wants to be involved. It's really hard for us as a team of 2 people to keep tabs on all 50 states. It is really, really challenging. And so with participation from other people across the country, it can actually be feasible.